front of you. We just reordered the policies so that we're hitting the most prioritized ones first to make sure we can hit those tonight. This will be, let me back up just a little bit. This will be kind of a less formal format, obviously, than a regular board meeting. We'll still manage the discussion time so everybody gets their share of mic time. Any questions that you didn't have the chance to ask the admin team, since the packet went out to us, you can direct those questions to Chuck. They don't have to come through me in this format. As I mentioned in the email earlier, I want to propose that we set an end time for the meeting tonight. This was one of the suggestions that Greg brought forward when we connected the other day. And I think it's wise because from what he has found with going through the policies, there may be a lot of lengthy discussion. So it might be worthwhile to set a time limit for us tonight, and then anything we don't hit, we can schedule another policy committee meeting to address those issues or to address those policy changes. The ones that we do have to hit tonight, those are prioritized first. That's the treasurer policy because we had postponed that from the September meeting. So we need to address that so we can vote on it at the next meeting. And then the non-discrimination revisions, there's a variety of those policies. Those are all grouped together, and we'll take those. We'll kind of take them one by one, but the biggest chunk is the revised policies. There are 3 identical. We'll talk through that when we get there. So with that in mind, are you open to a 2.5-hour meeting, say set 9 p.m.? Is that adequate? Do you feel that that's enough time, too much? Anybody?
I'm fine with 9. 8:30 I think would be better, but I'm fine with 9 as well.
Okay, how do you guys feel? Do you feel that that's enough time to cover the items that we need to cover tonight?
I hope so.
No comments?
I feel like 8:30, 9 o'clock.
Okay,
Yes.
what do you think?
Seems like a good goal to me, yeah.
Okay, you guys good? All right, so that's what we'll aim for. Again, let's try to get those prioritized ones first, and then if time permits, we can start covering some of the other policies as well. So the revised order is on the printed agenda there at the table, or here at the table. We've prioritized those items that need to be voted on at the next meeting. And then we'll cover all the rest of them in order once we get to that point after the non-discrimination ones. So we'll begin with 171.4, which is the treasurer policy. As mentioned, the vote on this policy was postponed at the September board meeting in order to allow further discussion at the committee level. There are 2 versions in the packet for consideration. One mirrors the secretary policy that we approved at that September meeting, and then the other one is the one that Mr. Keller had brought forward for consideration. So given that, Mr. Keller, do you want to kick us off with the discussion on this?
Sure, thanks. So for the treasurer policy, I know there was some concerns over the policy that I had submitted. I did not get a chance to connect with Mr. Campbell. I know he was away on business travel, so I think kind of for that reason, and given wanting to maintain some consistency and things like that, I guess even though I preferred the policy that I had put forth, obviously, I'm willing to kind of use what was already in place, at least with the changes that we have in front of us on page 1. The only thing that I may want to add, but kind of within the same framework that we're looking at was, and I think this went well, I was able to participate in our annual audit with Rachel, CFO. Kind of went through together collectively with myself, Rachel, and our auditing team. Was able to participate in that draft report. And I think that as treasurer, that's something that whoever sits in this spot should go through. So I guess I would propose that maybe we take, and we would slot C as now D, and then add a C perhaps, and have something that said, participates with the CFO in the district annual audit.
So do you see that as a requirement or the opportunity to do that? So it may participate?
I mean, I would hope that any treasurer would do it, but
Sure. But if for some reason, say, time constraints, whatever, scheduling, whatever, it's like, could that still happen then without the treasurer?
Yeah, I guess we wouldn't want it to be something that was held up, but I think it would be a good practice for any treasurer to go through. So I would potentially be okay with a May.
Mr. Hughes, can you let us know in the past, do you know, since I have not served as treasurer, how many previous treasurers that, as far as you know, have attended that before? Do you know?
Yeah, everybody, all treasurers have attended that, especially when we used to have finance committee. That's usually where we did it. We had 3 members there and we went through that. My suggestion maybe that would help Mr. Keller is under CD, perform other duties as may be authorized by the board, required by law, or appropriate to the duties of the office of treasurer, such as financial audit conversations or involvement.
Yeah, I considered that, but I guess the concern that I had was that in that case, we're actually delegating it to the superintendent or CFO. So then it doesn't necessarily indicate that you should do it. I tried squeezing it in A, but I didn't think it kind of then became sort of a run-on, so I thought maybe it should be sort of its own item.
It's up to you guys.
And I didn't know Rachel wasn't going to be here, but maybe I can get with her after this meeting just to see what her recommendation would be for that.
Can I make a comment about that? Just remind the board, when you passed a resolution back in December, I believe it was, the resolution to have committee of the whole, the first order of business on that resolution was administrators were not required to attend. So I said to them, there's no sense in you sitting for 3 or 4 hours. If there's questions, I would get them and bring them back to them. So just so you know, that's why they're not here.
Thanks. I agree that it would be a lot to add some of that verbiage to item A. So do you want to take that as an action item to follow up with Rachel to see if she's got a preference on where that should fit or how best it would fit? And then make sure that revision gets to Renee so we can include it in the packet for the vote at the next meeting.
Yep, no problem.
Awesome.
So I captured, so everybody know, I captured C, made CD, and I just said participate in financial audit reporting. 'Cause that's kind of what it is, the end of the year report. And I'll hit Rachel first thing in the morning so that she is aware you're going to give her a call.
All right, just capturing that in my notes.
Unless she's watching tonight, but who knows?
All right, and then you'll send those edits to Renee. Okay. All right, any further discussion on the treasurer policy? Okay. All right, moving on then to the non-discrimination revisions. There's a lot here to unpack.
Can I make a note on that?
Sure.
Just so the board understands, all 3 of these policies, 1422, 3122, and 4122 are the exact same policy. It just goes in different sections of the policy book, administrators, professionals, and support staff. So they're all 3 exactly the same, so I think if you come to agreement on one, it's going to apply to all of them, just so you're aware. And you'll notice as well that these policies are updated, and the other policies under non-discrimination will be rescinded because all the information was moved to simplify it into 3 policies versus having multiple policies.
Yeah,
Just so
9.
you're aware.
3 is better than 9. All right, so I'll read some of this as intro just to give us some context, and then we can kick off some discussion. So from Neola, They indicate that largely at client request and in an attempt to streamline the complex collection of non-discrimination, anti-harassment, and related issues, several of the policies have been consolidated in order to provide a comprehensive approach to related employment issues. The definitions included are consistent with related policies, and the grievance process is designed to be consistent throughout the investigation, decision-making, and appeals stages. So adoption of these three policies that Chuck mentioned, 1422, 3122, and 4122, allow for the deletion or rescission of 6 other policies, 2 related from each of those 3 employee categories. All of those numbers are listed in the packet. And then in addition, which we'll get to these after we address the 3 big ones here, there are 5 different policies that have technical corrections, correcting the address and contact information for the U.S. Department of Education Office of Civil Rights, because that has, it's no longer in Cleveland. We're now using a Washington, D.C. office for that. So we'll get to those in a moment. In the packet, there were some notes provided by Chuck and his team that gave some of the rationale and explanation for the options that they selected from the Neola packet. So we can refer to that as we go through. I'm not going to bother reading all of this because without seeing it or referring to that specific excerpt of the policy, the notes won't necessarily be clear if I read them straight through. Let me make sure that I covered all of the notes that I wanted to mention. All the related policies. And then as Chuck said, the intent is to end up with 3 identical policies, 1 for each of those employee groups. We'll focus on 1422. Let's just look at 1422 for the discussion. That will help limit some confusion and I think limit some page turning during the discussion. Please assume that any changes we make to this policy would then apply to the other 2. If you have found any technical discrepancies between the policies, please submit those to Chuck and Renee so they can make those appropriate small changes, like if there's a punctuation or one word is different or the tense of a word or something. We don't need to take up a lot of time to review those small discrepancies here in the meeting, as long as they're not affecting the intent or content of the policy. Those can be technical changes that we can submit to Renee, and those can be included in the final version that we vote on. I think that's everything that I have. Is there someone that would like to kick off the discussion? Any takers?
I have I think a quick note or question.
Okay.
And it's not just for this, but a lot of the policies we're looking at tonight have our district compliance officers listed. And there was a note from Neola, I don't know where it is in all those pages, but somewhere in all that, there was a note that they recommended a male and a female as compliance officers. Is this a conscious decision not to do that? Is it the fact that we just don't have a male and a female? I'm not questioning it. That was their note.
We've always operated from our human resource office is the one that handles these types of situations. So if you're going to reach out, you want to talk to the human resource. They're the ones that have the expertise. So in the past, for instance, Scott Van Epps was a male, Anna and Carol Hayes were females. Now that Kate is over there, Kate knows the law. Kate is expected to know the law. She leads all of those. And then Anna's her second, in case someone would rather go to Anna. So it just so happens we have 2 females. I don't know that, I get the, it would be nice potentially for someone to go to a male, but this works and it's legal and yeah, it's a good recommendation, but if we keep it within the human resource department, which is, again, their expertise, I think that's where it should stay, personally.
To answer your question.
Yeah.
Okay.
It might be nice if we had, I don't know how often this comes up or if they have, if there was somebody who was more comfortable with a male, if there's a way to handle that, I don't know.
Keep in mind also, Board, that you can bring people with you, right? So if you want to file a complaint and you're not comfortable necessarily with just a female there, you can bring a support person with you. That's certainly within your right to do so. So that happens. And we have, within the law, there's investigators and decision makers. So investigators might be Tom Urich, who's an investigator, Jason Reck, who's a male, who's an investigator, Jessica Gus is a female at the high school. So, and Dave Minsker is usually the decision maker. So there are males that are in there that will have contact with you as you're going through the process.
Okay, would anybody like to start with the discussion then?
I have some questions. Let's see. So on, I guess it's like the fifth paragraph down of 1422, starts,
What page?
which packet?
Well,
Page 2, it looks like.
we're going to need to know page number.
Oh, sorry, page 2 of 19. Perfect. Let me know when everyone's there. Okay. So it says, "The board will take immediate action to address the following prohibited acts." So I was just trying to understand, given that we have monthly meetings and, we're not necessarily engaged in day-to-day, how would the board be made aware of that and like, what's considered immediate action legally?
So keep in mind that when you look at board policy, this policy is the policy of the board. So whenever you see the board, it's the board or the designees, right? So in this case, the board will take immediate action to address the following prohibitive acts. It's really the expectation that the individuals that the board has on salary within the district are taking care of those things. So you will see that often throughout policies, the board, it's a general comment of the board. It's just the way it always is. So, so the board taking immediate action on retaliating against the person who has made a report or filed, like, that's our job. And certainly if it makes it to the board level, because someone calls you as a board member and says, holy moly, someone, retaliated, then certainly you would be calling us and saying, what are you doing about it, right? So your immediate action would phone call to Kate or Anna as a compliance officer, say, what's going on here? Take action on filing a malicious knowing false report. Again, it's prohibitive conduct. We would have to deal with that. Disregarding, failing to appropriately address or delaying action. Certainly if you find out that somebody hasn't taken action, then the board would say, okay, Mr. Hughes, superintendent, what the heck's going on? Fill us in. Why is this not being taken care of? So the board is from that perspective. I hope that makes sense.
So going down to page 10. There was an option that says, that is checked. The CO may serve simultaneously as an investigator and/or decision maker. I guess, is there any specificity around when they might do that? So you kind of had the same person that's, wearing both hats?
Yeah. No, I mean, it could happen. Let's just say Dave normally is our decision maker, and Dave's indisposed. He's in the hospital, I don't know. So Kate might have to take that on, right? So the investigator done their job, or luckily for us, we have multiple investigators. I think I just told you we have at least 4 investigators throughout the district. So, we're going to have somebody, but the decision maker is Dave at this point in time. So he would be there, but if he can't make that decision, then Kate, the law allows Kate to do that. So she may do that. We obviously would try to avoid that just because it looks better when it's, because ultimately in these types of cases, the final decision is the decision maker's final decision, right? That's the final decision. That's it. That's what goes in, and we're done. So it could happen, but I think this just covers us in case something happens and the decision maker is indisposed. That's why we picked it.
I mean, I certainly think we need flexibility, but I would hope that would be sort of the last resort.
Yeah, absolutely.
And I don't know that this necessarily kind of indicates that.
Well, it does say may, may, but again, we could have not checked that, but we figured we should check that because of that flexibility component, just in case. Because you remember, there's timelines throughout this document, right? So you have to hit certain timelines.
A few, like 2 paragraphs down where we selected board president as opposed to board. It's in the circumstances when the CO and trained administrators do not have time, capacity to serve, or are prevented due to conflict of interest, bias, partiality, or other reasons impair the CO and other trained administrators from serving as an investigator, decision maker in a specific case, the CO shall, in consultation with and approval of the superintendent or board or president as appropriate, secure one or more independent third parties to serve as investigator. I guess curious, board president versus board.
This again, because of the timelines, you know, if you have to wait to get the whole board together to have this conversation, it's probably better for everybody flexibility-wise on meeting the timelines to have one person to be able to go to. So we just picked the president. Just seemed like the right thing to do to keep in line with timelines and trying to get everybody together. As you know, it's not always easy to get the board together.
Does that put, an undue burden though on the president to then be properly trained?
Well, we couldn't do that unless the board president was trained. So if the board president's not trained, we got to figure it out and get it done. So it would go to me and I'd have to do what I have to do.
Would we have to change the job description then for the president to include that?
I don't know, I think the board president says, all duties or whatever.
I guess I read that differently. I read it as get approval of the superintendent or the board president to secure somebody
Yeah.
to do the decision-making or whatever, that it wouldn't be the board president.
I agree. I
Him
think
or
that's
herself.
how I read it as well.
That's how I read
And
it
for
too.
us, it would be the attorneys, and I think that's what the board president, the definition of the board president can make the decision to work with attorneys, secretary, vice president, board, consult legal counsel, school-related matters relevant to the board. So I think that's who we would use. There's been examples of us going to a third party to do so.
Yeah, it's not the president doing the job, it's the president approving, getting somebody else to do it.
All right, page 13. Under the determination of whether prohibited conduct occurred. Bullet A, it says use the preponderance of evidence standard for proof, and goes on to, list some other options. One is clear and convincing standard. I guess what are I've heard preponderance evidence thrown around a lot, and I don't think we've really talked much about the clear and convincing evidence standard. So can we talk about why we choose that? It seems to me that the burden of proof, if you will, is a little bit more lapsed with preponderance, I can't say it, preponderance of evidence standard.
Yeah, the law allows you to use, and the legal jargon is preponderance of evidence. So at the end of the day, our attorneys would say that preponderance evidence is what you're looking for, and that is, based on our understanding, he said, she said, she didn't say, she did say, 3 people said it happened, you say it doesn't, preponderance of evidence rules. So I could have a situation where 3 people say, it happened, and the person who we're addressing says it never happened. Is that clear and convincing? You make that argument. Preponderance of evidence, it's clear. I make a decision based on, I've got 3 people that outweigh 1 person, and that's good enough for me. That's preponderance of evidence.
But do you think that that would benefit the student or the staff if they're the ones that are, I guess, getting investigated? I know personally for me, I'd rather it be, beyond a reasonable doubt, but I know that's not the option here. But I would prefer to be as close to that as possible.
I would say preponderance of evidence in all cases is, we feel very strongly that it's clear. It's a preponderance. It is clear to us that the evidence overshadows what you're saying, and so therefore we're going with that.
Sorry to interrupt. I don't think that's the legal definition. I think the legal definition is like 51%. It's just anything over, like anything beyond a coin flip. If you're just have a hair beyond, maybe is true, that would be preponderance of evidence.
I can tell you in my experience of 35 years in public education, preponderance of evidence, the legal team will always tell you, sounds like there's preponderance of evidence there to us, and we would support, defending you on your decisions based on a preponderance of evidence. And it's never been an issue. It's always worked. I know you don't always like to hear it's always been that way, but preponderance of evidence is a really good standard, because the fact is, when we investigate, the evidence leads to our conclusions, and we don't suggest changing it.
Well, and in addition, I mean, Neola, who makes these recommendations for us, they also do not recommend going with clear and convincing. So if we have used this in the past, the standard has worked, and it's been successful, and it's typically accepted, then I don't see why we'd want to change it.
Yeah, I mean, I saw their recommendation was against it, but it didn't really give any rationale, so that's where I was trying to understand why we don't choose it, because I looked up the definition as well, and I also saw the same, 51%, which, that's a coin
3
flip.
versus 1 would be preponderance of evidence, right? 51%, 75%,
But
right?
maybe you only ask 4 people, right?
Maybe.
It sounds like we have the definitions mixed up, but we're using clear, what was it?
Clear and convincing.
Sounds like we're using the clear and convincing standard based on what Mr. Hughes is saying, that rather than the preponderance of evidence standard currently.
Again, I would point to their draft note there. If the board chooses to change this, which again, we're suggesting the board not change it, we'd have to go through all of our policies and find every place where it says preponderance evidence and bring all of those policies forward and make that change. And we're not suggesting you do that. I'm just, this preponderance evidence works in my experience, which hopefully we're given some credit for the experience that we have in dealing with issues, that preponderance evidence is a really good standard.
Well, and Chuck, I'm assuming you've been part of many, many investigations over the years, right?
Absolutely.
Okay.
Well, I mean, if you're the one being accused, right, which one would you prefer?
Well, I guess you could have the conversation about contracts. Would you rather have just cause if you're the leadership, or would you rather have, what's the other term we use? Oh, gosh. Yeah, I know. I know what it is. It'll come to me in a second. There's another term that we use that doesn't have such a high standard, right? So, we'd rather go with an area where, you know what? Hey, we're going to do the best we can. We're going to investigate, and often there's opportunity for appeals down the road, not necessarily in this policy once the decision maker makes it, but in a lot of other areas where there is avenues for that. So I'll stop. You guys can make your decision there.
Yeah, I mean, my preference obviously would be the clear and convincing, but, I'm also open to hearing why Neola opined the way they did. So I don't know if we can maybe take that as a follow-up to get some more reasoning
Sure.
for why they didn't recommend it.
Yeah.
Hopefully you got everything that Neola could possibly put out there, and lots and lots and lots of pages.
We did, but
Okay.
but they didn't give that justification.
I think that's probably more of a Thrun conversation, to be honest with you. I can ask for Thrun to do a write-up on why we want to use preponderance versus clear and convincing.
Or actually, if we can just kind of get a pros and cons of both. They don't need to necessarily even give a recommendation. I just kind of want to understand their opinion of the pros and cons of both.
Okay. What else do you have?
In B, so right below that, we struck through that option. It says, "And the procedures and permissible basis for the complainant and respondent to appeal." Do you know why we didn't
Yeah.
want to do that?
Yeah, because for the law, there is, the decision maker is the final decision maker, there is not an appeal. So therefore, there's no sense in having the appeal in there. We want it to end at the decision maker's decision, and it's over.
Does anybody else have any opinions on this, or no?
No, I'm good with it as proposed.
All right, then how about in D2? Coordinate the imposition of any disciplinary sanctions on a respondent, including notification to the complainant of such disciplinary sanctions. Is there a reason we wouldn't want to notify them?
I believe later in the policy, it does talk about the follow-up, and then all parties get the final notification, but we don't necessarily, I don't believe we necessarily always throw out discipline because of FERPA. So I think that's just protecting that piece, but I think the complainant and the aggressor, there's a term for that, I'm sorry, I'm a little light today on words, the perpetrator, they do get the whole report, to get everything in it, and there may be a time where we don't necessarily want to put the discipline in there, but I do think they might get it, but we just, again, didn't feel that this was the proper spot to mark that.
Yeah, I mean, I can certainly appreciate the FERPA aspect of it. I just think as someone who, you know, if you make a complaint, and, you know, the district says, hey, yep, we agree, and we did something, I think they would want to have some peace of mind that justice was served and want to be notified versus we took care of it. So I guess that would be my suggestion to consider.
Right, I hear what you're saying on that, but I feel like we would need to specify something about FERPA, that if FERPA applied
Yeah,
in that.
How
if
would
there was-
FERPA apply?
If there was a student involved, if the student was the one who's being disciplined.
Isn't this all employee that we're talking about right now?
Yeah, but an employee has rights too.
Not
So-
under FERPA.
No, but they have rights under employability rights, and I don't necessarily want to share all that with everybody on how I discipline an employee either. That doesn't create a morale, a positive morale, positive environment.
But it could also deter from that if they don't think it's been addressed, right? So you kind of make, I hear what you're saying, but I think it would apply in either case.
Well, it would apply in their record, but it necessarily wouldn't apply, to me sharing it with somebody else. It would be in the record on how I discipline somebody for something like this. It's in the personnel file for discipline.
On page 16, there is a paragraph towards the bottom. The district will not disclose information about any supportive measures to persons other than the person to whom they apply.
I know it's in here.
So page 16, that's the first one that I found. It's the second paragraph from the bottom.
Again, it's.
I don't, that's supportive measures though, right? Is that different
Yeah.
than discipline? Which I think we said, supportive measures are optional. I think in other locations I saw it, and we don't
Yeah.
necessarily recommend those.
All I can say is we didn't choose that. We didn't make that recommendation to the board because we feel that there's that gray area and that line that you may cross that we just didn't feel comfortable doing that, so we've not recommended it. Certainly, Neola has it there as, it's an option if you want us to. We just don't feel that that's the right thing to do. It's probably the
So if if we were to add that, if we were to check that box, then we would be required to do that.
Correct.
Right?
Yep.
If we don't check the box, it is still possible to do that, but it is not required because it's not written in policy. So it doesn't preclude us from doing that.
But wouldn't that lead to more liability with the, that individual who was found culpable of discrimination? Wouldn't that give them reason to sue the district or something, saying that they turned over records of sanctions to another employee when that's not in the policy?
Perhaps.
So if we're going to allow it, it should be in policy. Otherwise, we're opening administrators up.
Okay.
Thus, we didn't recommend it.
Anything else?
So
on
is the
this point?
consensus to remove or not include, I should say?
I'm good with not including it.
Yes, me too.
I am as well.
All right, so page 14, under option D for appeal of determinations, that one was not selected. I know it was an option, but I was just curious what the rationale was.
The big one that's crossed out, option 1?
Now,
No.
option D.
It's D.
Oh. For condition remedies, including disciplinary sanctions and consequences, are unreasonable in light of the findings of the fact. Again, we just feel like the district has to have the ability to make the final decision and the decision maker. And so, it's not appealable. If I say to you as my employee, I'm putting you on a 5-day suspension, you go, that's unreasonable. Like, no, that's what we're doing. That's done. It's over. We're moving on. That's how I read that. We don't want you saying, well, that's unreasonable, I want you to do X, Y, and Z, and we just keep hashing it out.
So along with that appeal, so back on page 13, we said we were not going to notify parties of the right to appeal. Why would we not notify the parties of the right to appeal if there's appeal in our process?
I'm sorry, where did we say that we're not informing them? of
Page 13, B, notify the parties in writing of the determination, and then we crossed out, and the procedures and permissible basis for the complainant and respondent to appeal. And I thought what was said at that point was we don't allow appeals. And now on page 14, we're saying we allow appeals. Here's the process. So if we're giving a ruling and we have an appeal process, in anything else we do, we would notify the individuals of their right to appeal.
I'll make a note to Kate on that and ask her, why.
I can't think of a single other thing in our policy or in law in which you don't have to give people their rights to appeal.
So you're right. You're right under option 2 that we chose. There is the superintendent. You can appeal to the superintendent. So maybe we need to add that back. That may be a change that I'm not totally up to date on.
That was page 13. It was one you had brought up earlier in the
13B.
conversation.
Well,
Well,
I
he-
have a note to ask Kate.
Because we've tied it now to that item on page 14.
Because clearly we chose option B as the superintendent as the appeal process, so you're right.
Mr. Keller, do you have any others? That's okay. Yep.
So this is I think it's page 15. When it talks about, sorry, it's right after the big drafting note paragraph, starting with while a party appealing a determination, it goes on to say the party may not submit the new or additional evidence during the appeal process. Just trying to understand why that would be the case. If you have new evidence but you can't submit it, is it because it's used somewhere else? Or why would we not allow them to submit new evidence?
Again, this is from our attorneys. This is based on their best knowledge of the law, that it's not required. So I would say that I'm just going with the attorneys on this one. I don't know enough about that, and I don't want to get us into a situation where we're not following the guidance of the law.
I don't recall comparing that paragraph with, or the original policies that we have in place, so I don't know if that verbiage already existed in a previous policy, or if it was, if it was part of the merge from all the policies, putting them together, or if it was something separate that was added in. But if it was existing in our current policies, I wouldn't see a reason to change it. But again, without input from either Neola or Troon.
Well, and it does go on, if you read the rest of that paragraph, that if the decision maker chooses to listen, so it gives the flexibility there again, then it's set, and then it ends, if the appeal decision maker accepts the proffered explanation, the appeal decision maker should remand the case back to the investigator. So it does give the out there, well, you shouldn't be providing, bringing new evidence to the table at that point in time. If you want to explain why there's new evidence, then the decision maker can listen to that and remand it back.
Oh, yeah, so it
gives
may
you a
be
process.
submitted.
Yeah, but I think we just want to make it a fair process, right? And if there's new evidence, they should be able to provide it. Especially when we have such, if we're going to keep the preponderance of evidence standard where it's a coin flip, plus 1%. It seems like almost everything is kind of favoring anybody to make an accusation.
Well, I mean, again, we're not attorneys, right? And if you go to the front of this, there's all of these USC blah, blah, blahs that are referring to it. So I don't think making a change to this process until we get, if you're looking for an additional legal opinion, I don't think we should make any changes. I mean, updating a non-discrimination policy it's a pretty big deal, and I don't think we want to make changes to it unless we understand
Yeah, and that's why
what
I'm
we're
asking the
changing
question.
it to.
It also contradicts one of the policies we'll review later, 2266. In 2266, under the appeal process, it specifically says new evidence that was not reasonably available at the time the determination regarding responsibility or dismissal was made that could affect outcome of the matter. So in 2266, we're saying new evidence is specifically a reason for appeal.
What's the name of
Does
that
it say
policy?
within? It's
It
this one right
does.
here. Does it say within the context of the appeal process to bring forward new evidence? Because that's what this is, right?
Right.
This one says within the appeal process that they can't, or that they shouldn't, and then, but it can be accepted.
This
so-
says for appeal.
Okay.
The title of that section is appeal.
Perfect.
Both parties have the right to appeal from a determination regarding responsibility or from the Title IX coordinator's dismissal of a formal complaint or any allegation therein on the following basis, and new evidence is one of the items.
Well, I will talk to Kate tomorrow, and so what I hear you saying is on page 15 of 19, in this policy, we're talking about drop the not, so may submit new evidence. Your concern is the not, is that correct? It says the party may not submit. You don't like the not, is that correct?
Yeah, and then, the last sentence of that would ask as well, every reasonable presumption must be made in favor of the original determination. So it kind of sounds like you're saying you're reviewing, it has to be somewhat biased in what the original favoring was. It's like, the football field, the call on the field stands, right? But doesn't necessarily mean it's accurate. So
However,
maybe that's what it needs to be, but again, just trying to understand why it has to be that way, because it seems one-sided.
I would say if we drop the not, then it does allow the decision maker to remand the case back to the investigator, and therefore, you're looking at all that. The investigator moves it forward, then every reasonable presumption must be made in favor of the original determination, if that's what they decide. So I think the key there is the not. I'll talk to Kate.
I think the last one that I had for this was under the appeal decision maker shall, starts on the end of 15, and then we choose option 3.
Yeah, shall be final. That one?
Yep.
Yep. That's where I was going with earlier, because I know anytime I ever deal with anything, and my decision shall be final, like it's ending, and our attorneys are the same. They're on that same page. Like, once the appeal is made, once you make a ruling, it is final. End of discussion. So shall is better than may in that case.
Well, I guess I wasn't necessarily looking at that, but it was more or less why we chose that versus, the other options that could come to the board potentially. Because I kind of feel like at some point, people need to, the people that they elect accountable, right? So,
I thought that was said to be because of timing. Doesn't that go back to going to the president only?
No, I think in this case, again, if it comes to the board, then the board would have an obligation to have a hearing, probably go into closed session, unless they chose to have it in open session, or at least request closed session. Board will make a decision on that, but again, we feel like this is the best option for how the district operates. The board is not in the day-to-day operations. We deal with things all the time. We make the decisions, and we try to keep things off the board's desk where we can keep them off the desk, as the board doesn't need to be dealing with all the day-to-day issues that might come up. So therefore, why send something to the board when we don't have to? The law doesn't require it. Let us make the final decisions, and certainly if you don't like the final decisions at the end of the day, you can slap me on the hand and say, you're a bad superintendent.
but how would the board do that if they didn't have any knowledge of the incident or any, there would be no way to do it? Not saying that the board should, but
Things have their way of getting to the board, as you know.
I just feel like from the employee's perspective, they should, if at the end of the day, the board's the top of the org chart, right? And to not be able to take it there is a little bit, I think, strange to me, because at the end of the day, that's, that's like saying you can't go to the Supreme Court.
We're not in charge of personnel. I would not want a decision about an employee.
But this is only an
come-
appeal, right? This would be a second or third appeal.
Correct. I think 2 appeals, going to the superintendent, this is not an issue that I would want to, I think it's crossing the lines of what a Board of Education is here for. I'm not here to make decisions about personnel and if an appeal is correct or not. Again, the number of years of experience that this team has dealing with these issues, I have 0 hours, 0 minutes. So, yeah, I would not support at all these appeals coming to the Board of Education. I think that is just blurring the lines of what our role is as a Board of Education versus what the role is of the superintendent's office.
I'd be a little bit worried too about not having maybe the adequate background or training that might be needed.
Right.
And what ramifications may come to the board if we don't have that kind of training and then it's an appeal and we're making the final decision. Just a thought.
But it is an option Neola offers, right? So I don't
It
think
is.
it's, and again, it's only an appeal. It's not like, how many hearings have we had for expulsion in the 3 years? It doesn't come very often, but again, it's about allowing that process. I don't agree that probably none of us wants to be sitting in a bunch of appeal meetings, but if it's our duty, then that's what we signed up for.
Well, again, I would argue, as I always do, that the board has 1 employee that they hire, and that is the superintendent. And the superintendent ensures that we give everybody due process, fair treatment, make decisions. And at the end of the day, if the board is not happy with, they hear about a decision here, someone complains to them about a decision there, they contact me and say, boy, that was, help me understand, and they still don't like the way I did it, then they can address me on it. But that's the role that the board plays at the 50,000-foot level. I'm at the 20,000-foot level, and we got a lot of people taking care of business. So we feel, again, we wouldn't advise the board to take that on as a board. Let the professionals that deal with this every day deal with it.
So can I just talk through what this means in a real-world scenario? So an employee believes they've been discriminated against. They file a complaint. They're told, no, you weren't discriminated against. They appeal. You say, no, you weren't discriminated against. Now, is what you're saying that they should have the option to then bring that to the board, in which case we would be trying to identify if that employee has a valid claim. Is that accurate?
Without the training, without the experience, without the whole gamut of skills that your administrative team has to handle these things. Because the fact is, as a board, and I don't take this lightly, and I'm not saying it lightly, the fact is that your skills are different than the skills of those people that you employ in this district, or that we employ in this district to get the job done. And you have to trust that they're making the best decisions, and it's got to end someplace, and it's best that it ends before it gets to this in the public light. It shouldn't be there. And our thing is, no, the board should not be involved in that. Let us handle it. Let us do the job.
I hear you, Mr. Hughes, but with all due respect, I think it's not a popular opinion from some in the community that final decision is not appealable to somebody that's, an unelected official. And, we've seen that. I'm not saying with our district, but there's other cases of government where this has been a problem. And I think to not allow that, I just don't agree with it. But again, that's my opinion.
I recognize your concern. I get it. But I think with what Danielle mentioned, you say it's just an appeal, but we would still have to consider all the same facts, all the same evidence, all the same things without the same training, without the same experience. So I don't know that an appeal to the board would provide a a better or more informed decision than what Chuck or his team would be able to provide. Because we don't have that training or experience. I guess that's where my hesitation is with adding the board in.
Has anyone discussed this with teachers or?
Do you mean with the union
Yeah.
representation?
Yeah, I mean, if they're comfortable with the appeal process as it is.
I would imagine that there is verbiage in the union contracts that address employee rights, all of those things. I haven't read the entire, any of the entire union contracts to know, but Chuck, would I be correct in saying that this is addressed in those contracts?
All employee contracts have grievance procedures that if they're not happy with the decisions made, there's grievances available.
Even if it's a Title IX decision or a discrimination.
There may be some limitations there, but they could still have the opportunity to grieve, and it could be something that could go to arbitration, you know, if they really felt strongly about it.
I think that's what Mr. Keller's getting at. If making sure that there's a place to go, if they feel like, you know, if somebody truly feels like they've been discriminated against and is told, no, you haven't, appeals, no, you haven't, is that, and they still think they have a case, what can they do?
Again, I hear what you're saying, but I think that's a slippery slope that you have to trust that your administrative team, with the knowledge that we have, with the training that we have, that we're making the best decisions possible, and we will work with those employee groups if we need to. And we have a good relationship with our employee groups, and we certainly don't intend to not treat everybody with respect and dignity.
Was that your last one on this, Mr. Keller?
Sorry, no, I'm still going through them.
Okay.
But I think the other two I can skip for now, so. That's it.
Okay. All right, Mr. Scott, do you have any other discussion items regarding this policy?
No, ma'am.
Okay, Ms. Custodio?
No.
Mrs. Shaw? Okay, we addressed my two questions among those that Greg had. Let me just verify. And then, yeah. Okay, I think I've got all mine covered. Last page, yes. Okay, so we have a couple of follow-up items that may affect a couple of the options that we discussed here. We'll circle back. So, Mr. Keller, you had a follow-up? Or no, was that on the treasurer item? Treasurer. Thank you. All right, so scratch that. So, Mr. Hughes, you have a couple of follow-ups to get back with the team, touching base with Kate on those few options that we discussed. And then whatever input you provide, we can then apply to the other policies accordingly. Okay, let's see.
I'm quickly going through the next one, and it looks like it's the same stuff again. So I think these are all identical, so
Yeah.
whatever we find for the first one will apply. Whatever you decide will apply to all of them.
Perfect. All right, so Is there anything that you guys would like to discuss regarding the rescinded policies that result from making these changes to those 3 policies? Are there any questions or concerns regarding those being rescinded? Okay, sweet. Makes that part easier.
So the rescinded ones will go on as rescinded,
Yes.
okay?
Okay, so then there are 5 policies with the technical correction that was mentioned in the Neola write-up. It's the new Civil Rights Office address. That's 2260, 2260.01, 1623, 3123, and 4123. Are there any questions or concerns regarding those technical corrections on those policies?
Yes.
Okay.
All right, so let's see, 2260, page 2,
2260, we'll get there.
under A,
Oh, you know what?
curriculum content.
Page 2, curriculum
I
content.
think so.
You there?
No, I don't know
It
that.
says review, very first sentence, review current and proposed courses of study and textbooks to detect any bias based on protected classes. What exactly would that review look like, and how do you conduct something like that? It's pretty broad.
So the curriculum department, whenever we're looking at resources, whenever we're looking at things, for instance, all new books that come in, we actually read through them, and we look for anything that might not be acceptable for our constituents and our community, and we take a look at that. So when we talk about bias, right, we talk about, is there bias towards, is there a leaning preference towards doing X, Y, or Z? So it could be in nationality of individuals, could be in a number of different categories. So we look at that. If we see nothing wrong, then we would say, okay. The nice thing is that the board will see at the next board meeting, Mr. Fitzgerald will bring the high school course changes to the board, all right? Instead of doing it in committee like we used to, it'll be in the public. So he'll talk about those as a discussion item at the next meeting. So you'll be able to see what those courses of study look like and what we're recommending. If we bring textbooks, which we haven't purchased textbooks in years, a lot of what we use is open source or staff-created resources. Textbooks just don't seem to be the way that we go. The textbooks we do have, I think there may be some still in AP classes. Is that right, Laura? Just, yeah. But we've not brought new textbooks forward in a long time. So we're just looking at them to make sure that they are in line with what we feel the board is looking for. We don't want people at the podium screaming that it's a bad resource.
So, page 3 of 9, right in the middle. Last sentence of the third paragraph below the compliance officer listings. Says a copy of each of the acts and regulations on this notice, on which this notice is based, may be found in the CO's office. Seems like a pretty specific place. Would it be easier to just put that online as opposed to in someone's office where it's harder to access?
We could look at that. I know that we have posters around the district that we have to post in all of our teacher workrooms. I believe a lot of this information is there, that it's in all of our school buildings. If I'm not mistaken, I can double check.
It just seems like a lot of what we point to in all these policies talks about going online, so I
Yeah.
mean, it'd be fine to have it in the office, but I think having also a copy online would be appreciated, especially dealing with ADA and other issues, right? So,
All right, I'll make a note to look into that.
And then the very next sentence, I'm just curious what the purpose of that is. It says, "The superintendent shall annually attempt to identify children with disabilities ages 0 to 25 who reside in the district but do not receive public education." I guess, is that a law that you have to do that?
Correct.
And what's the, I guess,
Yeah.
what are you trying to accomplish with doing that?
Yeah, it's basically the law allows parents to receive help for their students as early as speech therapy and 2 years old. If you come to this building during the day, you'll see parents walking their children down to receive services. Or we work with LESA to provide services to get students started early. We have a Great Start program down here as well. That's LESA program for the early ones that need additional support early on. So we're always open to, we have to be open to, it's expected to be open to. And remember that students can also stay in our school system until they're 26. So it says through 25, but when they hit 26, now they go off and they may enroll in LESA. Well, LESA even only takes them until they're 26. So our students, when they graduate as seniors, we have some that will stay back an extra year with us, but they get what's called a transition diploma. That allows them then to go to the pathway program at LESA. So we just have to ensure that we cover this in this policy, that we provide the gamut of services for those age levels.
Page 4, first paragraph. It says, "While there are no time limits for initiating complaints under this policy, individuals should make every effort to file a complaint as soon as possible." It feels like in all the other ones, we have specific hard, fast deadlines, and I just was curious why in this particular one, Neola doesn't add.
You're on page 4, you said?
Yes.
Yes.
And we're on 2260. What paragraph on
Last-
page 4?
Last sentence of the paragraph at the top.
First paragraph.
Oh, your print is a little.
My print must be wrong. What's the paragraph start with?
Members of the school district community.
Right here, right here, right here.
Oh, okay.
Yeah, while there are no time limits for initiating complaints under this policy, individuals should endeavor to file a complaint as soon as possible.
Is there a benefit to leave it that open-ended? Like I said, a lot of them are like 30 days
Yeah.
or 10 for this, 5 for that.
I think, I would say, again, I'd have to digest this a little bit. No time limits for initiating. So it's the initiation, not the act. Once it's initiated, timelines start hitting, right? 5 days, 10 days. So maybe someone has a complaint and they haven't said anything for a year, but all of a sudden, a year later, they go, hey, I want to bring this up. This has really been impacting me for a year. And I wanted to get out of that space before I brought that complaint forward. And so I guess regardless, this is just saying there's really no, there probably is, for the district to deal with the complaint, there's no real statute of limitations, I think is what they're saying. Legally, there may be statute of limitation issues that you have to deal with if you're going to go and file a civil suit or whatnot. But for our purposes, we need to address it. It's just saying you can't sweep it under the rug. And again, I don't think this changes the policy. This is policy we currently have.
Okay. Again, just my observation. Next paragraph, third sentence in, unlawful discrimination based on a protected class. So does this not apply to everyone in the district?
It does.
Or is it only applying to what legally is defined as a protected class?
No, it applies to everybody, but legally you have to have the protective classes covered.
But if, again, if we just said all?
Again, I think the way it's written is to be legally defensible, that we have that verbiage in there, but you're right. All are protected. Yes, there's protected classes that are statutorily put out there, like we took it out of our respect verbiage, under reason, respect, and responsibility. But I would say that it needs to be there for legal purposes.
Well, isn't the context of the policy discrimination. So, and aren't the protected classes part of the definition of discrimination?
I mean, I hope everybody's part of it, right? Regardless of, again,
Sure,
I'm
but
not
it's
trying
like, but to
play
define
semantics, but-
discrimination, and if you're not part of one of the protected classes, does the term, do you use discrimination, the term discrimination in the same way? Does it, do you feel what I'm saying? The, I think that's kind of the basis of what discrimination is, according to these policies, is it's dependent upon a protected class, a member of a protected class being involved in a situation in order to be discriminated against. So I don't know if I'm stating that correctly. I can tell that it's not getting through, sorry.
No, I hear what you're saying. I guess I just don't know if I agree, but that's just my opinion. Because you could have two people from protected classes harassing each other, and then does it not
Right,
apply?
harassing, but this is about discrimination.
Or discriminating.
Okay, but discriminating on what basis?
I guess they could be discriminating amongst each other if they're protected, they're both protected classes, right?
Or there could be bullying going on, and it might not be defined as
Right, yeah,
discrimination.
bullying is not discrimination.
Right, so there could be a number of factors.
So based on this policy, though, if you're not in a protected class, you're saying it doesn't apply?
I would disagree with that, because I think legally you have to use the protected class language. This is what it's there for. That is under the anti-discrimination laws. They talk about protected classes. But I think that you could certainly have a situation where myself as a Caucasian white male may feel like I'm being discriminated against by some other individuals. That could happen, and then we'd have to investigate that as discrimination if indeed we find that that's what it was.
would
Again,
agree.
treating everybody with respect and understanding their
that's-
situation.
but I
That might be,
still-
again, it might be a little different, but you're still going to follow a process. You're going to investigate.
Right.
You're going to find out what's
right, but
going
that,
on.
But something like that might be under a harassment policy or under a bullying policy or under something else. But this is discrimination, which I understand it as it's based on those protected classes.
Right.
So, yeah, discrimination and access to equal educational opportunity.
So while I hear Greg's concern,
Yeah.
I certainly wouldn't recommend getting rid of it, like it needs to be in there. But I hear what you're saying, and I think that we would have to look at that.
Okay, jumping ahead to 6, again, just highlighting the uses the preponderance of evidence standard, so kind of the same request from the other policy, just to get the legal,
I'm sorry, where did you say that was?
page 6, right in the middle, under the ABCD, that paragraph, second to last sentence, in determining if unlawful discrimination or retaliation occurred, a preponderance of evidence standard will be used. And then 4 paragraphs down, the decision superintendent shall be final. Again, my same comments sort of apply for that one. I think Neola gave an option 2, says a complainant or respondent who is dissatisfied with the final decision of the superintendent may appeal through a signed written statement to the board within 5 days of the party's receipt or the superintendent's decision. We did not include that.
No, again, same reasons why we didn't include it earlier.
I think that's all I have for this one.
Mrs. Shaw, do you have anything else?
Nope.
Mr. Scott?
Not for these.
Okay. Ms. Custodio, do you have anything else for 2260?
No.
Okay, 2260.01. high sign.
That's just the change, really, the only change there is U.S. Department, Civil Rights changing.
Right, yep.
Page 4.
These are just that technical correction.
Yep.
but-
Yeah, I did have just a couple, I think they're just clarification points more than anything, but page 3 of 5, the complaint procedure, second paragraph, in accordance with section 504, says parents and students will be notified of their right. And then in the sentence after that talks about being notified of their rights. I'm just curious, is there a standard method of notification?
I believe it's in the student handbook, the parent-teacher handbook, parent-student handbooks.
What does it say?
I'd have to pull one out, but it gives their rights for there's a whole section on discrimination and how you go about making a complaint. I can double check that tomorrow.
Yeah, so here's another internal complaint. Let's see, next page, 405, step 1. The complaint must be filed as soon as possible, but not longer than 30 days. So again, that's kind of where on the previous policy, we're putting a date in there, but in the last one, there was no date. Trying to understand again, I think it's a Neola thing, but I'm wondering why they didn't.
Of course, in this case, it says, again, I would read that a little different than the one before because it says after disclosure of the facts giving rise to the complaint. So disclosure is, it moves from you to somebody else. That's the way I read that and interpret that. It's not you hold it yourself and you wait a year to say something, but this is where you've disclosed the concerns. Now you have 30 days to act on them. You've shared
file
that
the
with a
complaint.
counselor, you shared it with a parent, a teacher, somebody.
Okay, that's all I have for this one.
All right, Mr. Scott, you said you're good with this group of policies. Ms. Custodio, anything on this one? Mrs. Shaw?
Nope.
Okay, I'm good on this one as well. And then the next 3 are the technical correction. They're all identical, but again, hitting those 3 employee groups, 1623, 3123, and 4123. What do we have there?
I think I just had 1 or 2, hopefully easy questions. Again, complaint procedures, page 3 of 4,
Which policy?
3123?
1623, I believe.
1623.
I think they're all the same, right?
Yep.
They are all the same.
It's page 1 of the other packet, but,
Complaint procedures.
yep, same thing.
Yep.
Employees will be notified of their right to file.
Yep.
Just wondering how the employee is notified.
We have handbooks again, and I believe we also have posters in all the staff lounges, but I'll double check.
Okay. And maybe it's the same thing that you mentioned on the last one, but in I think it's same page, internal complaint procedure, B, second to last, or the last sentence, I guess, the complaint must be filed within 30 days of the circumstance or event giving rise to the complaint unless time for filing is extended by the district compliance officer for good cause. So again, I think it's kind of the same question as the other ones.
Yeah, this one's worded a little differently
Yeah.
than the last one.
I mean, I think it means the same thing.
Yeah, Cindy, what did the last one say?
Let's look at that one.
And it's the same in all of them.
This
Let me
one
just
just has
double
some
check.
extra words. for
Just
the
has some extra
sentence.
words, yeah.
Yeah, I mean, there's some nuances, but.
Yeah.
complaint procedure. It would have been
Again, it's-
2260.01.
We didn't look at that because it's our current policy, so,
Yep.
so check 30 days.
That's it for that one.
Okay. We just wanted to compare the two.
Right here. 30 days
After disclosure.
after disclosure of the facts giving rise to the complaint. So we can just have that be the same.
Okay. Okay, let's see, anything else on that group of three regarding 504? Okay. Okay, and again, if you find any other technical discrepancies, like between those groups of three, to make sure that they're all consistent from one employee group to the other, just send those to Renee or Chuck.
Should be for Glenn and Jeff since they're not here.
Yeah, Glenn and Jeff, if you're watching this recording.
Sorry.
Okay, so we are done then with the items that we absolutely needed to cover tonight. So yay, we can move on to some of the others and still be within our time limit. So moving on to the other revisions, and I forgot to mention this at the top, but this is intended, this discussion, this session is intended as our first reading, right? This is our discussion. When we bring these forward for a vote at the next regular meeting in a couple weeks, that is the second reading, and that's where we'll vote on those. So we're hoping that we're knocking out the majority of this discussion here at the table now, so that we can streamline the effort in that regular meeting in a couple weeks. All right, so moving on, Policy 2210, Curriculum Development. Approved courses. This is a revision to the existing policy. And stick with me for a second here. I just want to give us some context here. So from Neola, this policy has been revised to reflect the latest changes to the Pupil Accounting Manual, 2024-2025, Michigan Department of Education. And I believe Chuck and his team, revised policy to incorporate pupil accounting language. All recommendations are based on the current policy without taking those other template options into consideration. What discussion do we have on this
So
policy?
just to
Sure.
confirm, the pink strikeouts, we don't currently house in our policy, so we didn't even choose them, just so everybody knows.
Okay. Thank you. It's thankfully only a two-page policy. Ms. Custodio, do you have anything specific on this one?
No.
Okay. Mr. Scott?
2210, no, I don't.
Okay. Mr. Keller?
Maybe I'll just sit with Chuck to go, I don't want to belabor everybody's time because, I'm kind of interested in why we don't choose some of these options. I'm not saying that I would, but I'm just trying to understand the thought process. And if I'm the only one who's sitting here that wants to know that, I don't want to waste everyone's time, so.
So I'll put Greg on mine, question mark.
Yeah, because really it's a lot of questions about stuff that Neola offers as options that we don't choose.
Okay.
So unless you guys object and want to go through it, then I will ask, but.
I'm good with what you're comfortable with. If you'd prefer to ask it now, I'm fine with that.
It's okay, thank
Okay.
you.
Okay. Okay. Then moving on from 2210, if there's nothing further, 2266, non-discrimination on the basis of sex in education programs or activities. This is a revision to the existing policy. A revision to this policy and AG, that's administrative guideline, is necessary because of June 23rd, 2025, the National Incident-Based Reporting System definition of fondling changed. The term officially is criminal sexual contact. The terms sexual orientation and gender identity have been retained in the parenthetical definition of sex in the policy since these protections have been required in Michigan by the Elliott-Larsen Civil Rights Act, and specifically as amended by the Michigan Legislature in 2023. Neola recommends we discuss this issue with legal counsel before deciding to delete any language. It's critical that we consult with legal if a situation arises involving an allegation or discrimination or harassment based upon sexual orientation or gender identity. And then in addition, that same technical change is also made in this policy, the Civil Rights Office to Washington, D.C.
So the key on this one really is ensuring that the sexual assault definition matches statutory language. That's the one big change, and the other big change is the criminal sexual contact in fondling, and rewording that language so it matches as well. So those are the two real changes in this, just to make sure sexual assault and fondling are captured appropriately.
Mrs. Shaw, do you have any questions on this one?
Okay, thank you.
Mr. Keller?
Yes, page 7 of 14, under timeline, second paragraph. It's not listed here, but Neola has an option of, that says Title IX coordinator will provide the parties with reasonable updates on the status of the grievance process. Any reason why we wouldn't give status updates or would choose to not?
No, I think because it's already laid out, you have 5 days to finish this, 10 days to finish this investigation, 10 days to get the information out, that we're following that timeline, which means that we're making sure it's getting. Now, I will tell you, it doesn't mean that if you call and say, hey, what's the status of this, we don't give you a status, right? We talk to you, we treat you with dignity. But we're meeting the timelines as it is, and we're making sure all the information is being provided as expected. So we didn't feel that was necessary.
Okay. Again, it's an old question from me now, but page 9 of 14, the investigation, again, using the preponderance of evidence standard.
Yeah.
Because Neola does have an option for clear and convincing evidence. So, same question for that. Sorry, trying to flip through here. So page 9, third paragraph from the bottom, the district will provide to a party whose participation is an invited or expected written notice of the date, time, location, participants, and purpose of all investigative interviews or other meetings with sufficient time for the party to prepare. Can't read my note there. But anyways, there's an option that says the investigator and decision makers must provide a minimum of blank days notice with respect to investigate interviews and other meetings, days notice with respect to hearings. Since we normally specify all the, the number of days, is there any reason we don't want to do that here?
Yeah, if we don't have to, we don't want to. Like, the fact is, it gives us time to investigate, gives us time to make the phone calls, gives us time to say, hey, Mr. Keller, we're going to need to meet with you so that you have a chance to bring your attorney. And if you say, hey, I want to bring my attorney, we say, okay, when can you meet? So we don't want a specific time if we don't have to. There's some benefits to having a little bit of flexibility without always having to, if we can avoid a specific time frame, we do. Like the other ones you see 5 days, 10 days, those are reasonable. But in this case, it just gives us the flexibility to proceed and,
Well, and in some cases, sorry to interrupt, but in some cases, those timelines are required,
yes,
aren't they?
yeah. But in this case, again, anytime we don't have to take something, and Neola would tell you the same thing, if you don't have to take it, don't take it. If you don't have to box yourself in, don't box yourself in. And so we choose not to if we can.
If I've jumped in ahead of any of yours, you can.
Yeah, so just kind of going back to the beginning. So obviously, we know there's discrepancy between Title IX and Elliott Larson. But it's my view that this is a Title IX policy. Is that accurate? Since the whole policy has to do with how we enforce Title IX? And Elliott Larson is not referred to at all in the legal?
Well, I guess I haven't prepared for that answer, so I guess I would say that, the only thing I would say is, yes, it does talk about Title IX in here, and Title IX is absolutely essential. It is a federal requirement. However, we do also, whenever we're investigating, have to take into account state law, which is Elliott Larson. So
But not for a Title IX investigation?
not necessarily for the investigation, but certainly how you do
So our
business.
Title IX investigatory policy should not refer to anything that shouldn't be taken into account for a Title IX investigation.
I guess I don't know how we determine that this is only specifically relating to Title IX.
Well-
And I say that because on where it says legal at the top of the policy, it lists, Title IV, it lists a whole bunch of different
Six.
USC codes and.
And they're all
things we're
federal.
Familiar with.
They're all federal.
Okay.
So there's no state, so Elliott Larson is state, but everything in here is citing federal law, federal policy, and our responsibility under Title IX to conduct investigation. So where I'm going with this is the first sentence says, the Board of Education does not discriminate on the basis of sex, and then says, including sexual orientation or gender identity. But gender orientation and gender identity in themselves cannot be used in a Title IX investigation. And so that's why I think it's confusing.
I guess my only answer to you is anytime we do a Title IX investigation, we're talking to our attorneys, and our attorneys are giving us guidance on how to proceed, if they see any red flags, if they see anything that we should be aware of. So if it was a sexual orientation and gender identity issue, our attorneys would be helping us through that, still following federal policy, but also being cognizant of what your state legislation and what is out there has you doing. So we'd be working in conjunction with our attorneys anyway to make sure that we weren't violating any of that.
So, but I get that. I just think we may be confusing people if we essentially have a Title IX policy that's going into things beyond Title IX.
Well,
So-
But again, I don't see, it doesn't say Title IX in the name of the policy. I know it refers to Title IX, and it is based on what Title IX is and what it encompasses. But to me, that doesn't mean it's mutually exclusive from a state law.
Well, what in here would be state law? We have the Title IX process, the Title IX coordinators, the Title IX definitions, the Title IX
Well,
grievance
specifically, I
process.
was referring to the Elliott Larson Act that you brought up.
Yeah.
So to me, because this is focused on Title IX, doesn't exclude Elliott Larson from,
Well, it would if the Title IX investigation can't take into account Elliott Larson. It can only take into account federal guidelines.
I would disagree with that. Again, you're doing side by side, and it talks about sexual harassment in here, and Elliott Larson is about sexual harassment.
I understand.
So whether it's confusing or not, the fact is that our training You know, there isn't training on Elliott Larson investigations, Elliott Larson, that's not the training. The training is all under the umbrella of Title IX investigation, Title IV, Title VI, Title VII. Like, we follow all that in every instance. So while it might be confusing to somebody, like it doesn't talk about Elliott Larson in here, it's just Title IX, well, it's federal, that's the procedure we follow, but we also are, again, and I think you said you understood that, we're also side by side weighing all the state statutes that we have to follow as well.
It doesn't make sense that a Title IX coordinator would be weighing state statutes for a Title IX decision. That would be outside of the Title
It
IX
might not make sense to
regulations.
you as a layperson, but it makes sense to us as professionals in the business doing this work every day.
So a Title IX investigator can use state laws in their investigation, even if it conflicts with Title IX.
I didn't say that. I said we work side by side with our attorneys to make sure that we are delicately working through any investigation that we have to do and documenting accordingly and acting accordingly. So we wouldn't be doing this with, just because we have a really good resource, and that is our general counsel to help us through that process.
Right.
So,
So I still don't, I mean, there's bigger fish to fry here, but that we would pull in some components of Elliott Larson into our Title IX process in policy doesn't really make sense to me. So that's where I'm going with that. I understand what you're saying, but if you read this, all 14 pages have to do with Title IX. I don't know, there's nothing else in here. So I don't understand, and under Title IX, again, we can't use sexual orientation or gender identity in itself in any sort of sexual harassment or Title IX hearing under the 2020 guidelines, which is currently what's being enforced for Title IX. So it seems to me like you just talked about boxing yourselves in. Why box yourself in if you don't have to? Why would we say we're going to follow Title IX and we're going to follow an even narrower view of our interpretation of Title IX with also looking at the Elliott Larson Civil Rights Act? It just doesn't make sense that we would box ourselves in like
with
that.
attorney help. And so please, like, that's really important, with attorney help.
I understand, but this is still, we're putting it in our policy. So if Title IX does not consider sexual orientation or gender identity as sex, then why would we put it in our Title IX policy? That's where I'm going here.
Okay, so maybe that's a question that we need to follow up with someone from either Neola or from Troon.
Sure. And I know this
To
is,
determine that, because I think that's above all of our pay grades right here.
yeah, and this is changing. I mean, this, we have the court cases, we're just in, I think, June on that. So, they could have drafted this before. Maybe they have an update we haven't seen yet. I don't know. All right, so that was one. A couple things that I just thought were missing from this policy that I think would be good to add, and I'll kind of go through them. I've prepared some sample language I can read, or I can share it with you guys afterwards. 4 concerns I had. One, there's no mandatory law enforcement reporting on any crimes that are discovered in the case of a Title IX investigation. I think that should be in here, that anyone who discovers evidence of a crime must immediately report that. We've had discussions of that in the past, real-world examples. We don't need to relive those, but I have some language. Essentially, any staff member who witnesses, receives a report of, or has reasonable cause to suspect, again, I'll share this with you, sexual harassment or other prohibited conduct under this policy that may constitute a crime shall immediately notify local law enforcement. And then also a requirement that our Title IX investigator do the same if they come across any evidence. I think that's really key here. Second, parental notification. There was some limited language on notifying parents when their students are involved in these situations. And I forget if it was pretty one-sided. I don't remember if it was the complaint complainant or the accused, but I think parents of all students involved.
What page are you referring to?
These are things I think are missing from the policy.
So these are all things that you would want Kristen to talk to our attorney about possibly adding to this
right,
policy?
Right. So, so adding some requirement that we notify parents if their children are accused of any sex-based discrimination, or if their children are, the ones, because some of this is pretty serious. I mean, we have, this isn't just making crude jokes. Sexual assault, sodomy, incest, very, very serious things here, and to not notify parents, to not notify law enforcement would be a big problem, I think.
So even though under timeline, upon receipt of a formal complaint, Title IX coordinator will provide written notice of the following parties. Notice of the allegations of misconduct and potential constitute sexual harassment as defined in this policy, including sufficient details known at the time, identifying the parties involved in the incident, if known, the conduct alleged. So it goes on to talk about what we have to do, which is notify both sides of the equation. So I think it's in there.
Does it say parents? I mean, as long as it says parents, I'm fine.
Well, it just
What
says,
page you on, Chuck?
I'm on page.
Yours is different.
Yeah,
But that's also within 60 days. I mean, if my child is sexually assaulted at school, I don't think 60 days after you've made a determination is okay. I think if there's any accusation my child is sexually assaulted at school, there has to be immediate notification to both law enforcement and to parents.
I'm on 714 under timeline.
Oh, yeah.
Yeah, and upon receipt of a formal complaint, again,
Yeah.
if we don't need to wait for a formal complaint to notify parents or law enforcement if there's any indication. So the language I've drafted says essentially, except where prohibited by law, in cases of emancipated minors or court orders, the district shall notify parents or legal guardians in writing within 24 hours of receiving a formal or informal complaint alleging such sex-based discrimination, harassment, or the need for supportive measures involving their child. Again, I'll share this language with everybody, but I think the parental notification is going to be key there. Supportive measures is defined on page 4. And this is important. If you read through the policy, that's essentially the, as they say, non-punitive, non-disciplinary actions that can be taken, which is great. But one of these says counseling. And so I think we do need to make a note in our definition of what supportive measures are, that counseling be limited to non-therapeutic guidance or academic support by a qualified district staff member, excluding any form of psychological therapy or clinical mental health treatment. So if we're giving, counseling is okay as long as we're not providing therapy or psychological services to the students. So I would want to clarify that. And if we look at, supportive measures has been defined in the other policies we looked at today. The counseling was not one of the supportive measures because we were talking about employees. So just making sure we're staying within our bounds.
So let me ask a question, just because, you bring it up. So we have a situation, and as we investigate it, one of the supportive measures we want to put in place is for the perpetrator. And our supportive measure is, here's the deal. You're suspended until you have a psychological evaluation. We're concerned about you. That's counseling, but it's psychological in nature. So would your write-up preclude us from saying, no, you're not coming back until we have something from a psychologist that says that you are of a sound mind that you can even be in our building? Like, we could find something that's pretty egregious.
Yeah.
And that is the reality, and that's a common practice.
Sure.
And a common practice that a parent would want us to have, especially if I thought you were a danger.
Yeah, I don't think I define that as a supportive measure, because supportive measures are specifically defined here as non-disciplinary, non-punitive. So what you're talking about, you can't come
Well, the
back.
discipline is the 10 days out, let's say, or you're out until. That's just a condition. It's a supportive measure. It's a condition that the discipline is the suspension. The psychological evaluation is not punitive. It's, you got to have it or because you need it.
Yeah, no, I think that's completely reasonable. I don't think that, again, I don't think that would fall under supportive measures, and certainly not be carried out by district staff. So the main thing is making sure that we're limiting our counseling to what, making sure that our counselors are not, and our social workers and our school psychologists are not going outside of the boundaries of what they should be providing, just because a Title IX coordinator says, I want you to do this. We need to make sure that we're staying in line. And then if we are keeping gender identity and sexual orientation in here, which again, I think it is very confusing. I think it confuses but if we're going to keep it, if the decision is, okay, we need to keep that in there, attorneys say we have to keep it, then I think we need to make sure that that our supportive measures are not crossing any boundaries, especially when it comes to parental notification. So again, in my parental notification paragraph, I read you the first half, I'll read you the second half. In our notification to parents, I say the notification shall include a summary of the allegations or concerned, the proposed supportive measures, and an opportunity for parents to participate in discussions or decisions. No supportive measures affirming a student's gender identity shall be implemented without prior parental consent. Title IX coordinator shall document all notifications, maintain confidentiality consistent with FERPA. Now, if we are going to keep the sexual orientation, gender identity, I'd like some more language in there to make sure, again, that our supportive measures are not crossing any boundaries when it comes to gender identity and sexual orientation. So I have no district staff shall provide, refer, or facilitate any education, training, counseling, resources, or supportive measures specifically addressing sexual orientation or gender identity, including but not limited to discussions of sexual orientation, gender identity topics in response to allegations under this policy. Sexual orientation and gender identity focused materials or referrals to external supportive services to a student under the age of 18 without prior written consent from the student's parents or legal guardian. Consent forms shall be provided upon request clearly describing the proposed activity, content, and include an opt-out option. For students 18 or over, participation will be voluntary with a written acknowledgement. All consents, opt-outs will be documented in the student's file. So again, making sure we're not providing gender resources, sexual orientation resources to a student as a supportive measure without full parental consent.
Since we are getting close to time here, I just want to, so these changes that you are talking about are massive and have huge implications and obviously need a lot of legal support for us to make these decisions. What you're suggesting is not going to be possible to put on the November meeting for this policy. So, this is all stuff that's going to take a while for us to work through and probably have to be discussed again at the board table.
Yeah, I'm fine
So-
with that.
Imagine, yeah.
You know-
So if that's the case, Chuck, this is one of the other revisions, right? We moved this, we kind of deprioritized this
Yes.
with some of the others. So if we do not vote on 2266 in November, we're not hindering anything there?
Okay, that was going to be my other question is,
And I have, in similar, a lot of the same concerns for 551701 with the parental notification and the law enforcement notification. But in regards to bullying and aggressive behavior, making sure we have a requirement to notify law enforcement of assaults, cyberbullying that crosses a legal line, et cetera, and getting parents notified as well.
Okay. So if that verbiage is the same, or if you have it written up
Similar,
or it's
yeah.
similar, would obviously wouldn't be identical. If you send that all to me,
Yep.
then we can send it all to Trune all at the same time. So we can probably, if we get that far in the process here tonight, we can probably save the discussion for 5517.01 as well.
Yeah.
Does that cover all of your bases for 2266?
Yes, ma'am.
Ms. Custodio, do you have anything?
No.
Cindy, do you have anything? Okay.
All right, so I'm going to pull out 2266 and 5517.
.01, yes.
01, and we will deal with those at another policy committee down
Yes,
the
sir. All right.
road after Jeff sends us all this stuff. Will you
Right.
send it to Renee and I as well?
Yes, sir.
Perfect. All right, so,
Sorry, I just have a question on page 12, same policy.
sorry, okay.
2266.
Sorry, Greg.
No, it's okay. It's under appeal process, ABC. It says the complainant may not challenge the ultimate disciplinary sanction consequence that is imposed.
what page?
12. And then it talks about any party wishing to appeal the determination. So you can't, I'm trying to understand, does it mean you can't question the penalty, but you can question the decision? Is that the interpretation?
We're having a hard time. So you're looking at the whole appeals section? And is it on page,
It's very top of page 12, under C.
okay, so C, okay.
It says, the complainants may not challenge the ultimate disciplinary sanction consequence that is imposed. But then the next sentence talks about anybody
not-
that wants to appeal it,
Am I in the wrong policy?
like,
I'm
does
not
that just
seeing
mean you can't?
Line C,
2266?
yeah, right here. This sentence and then this.
Oh, I'm looking
These
at
two.
actually C, not under C. Okay, thank you.
So the complainants may not challenge the ultimate
So what is your question?
I'm trying to
don't
understand
understand.
its meaning when you look at that paragraph in totality. Is it saying you can only challenge whether the decision was correct, but you can't challenge a penalty? Is that how you read that?
Yeah, that's how I read it. So if I give you a 5-day suspension, you're not gonna challenge that. You're challenging the final decision that the decision maker, which is gonna be after the discipline, more than likely, right? The
So you can't-
decision-
you can't-
The final decision will be within a certain amount of time frame.
But you can't challenge whether or not you felt like a decision was too punitive. Meaning guy broke a pencil in the pencil sharpener and you got 20-day suspension. You can't challenge that, only whether or not you should get it.
Not under this policy. This policy's, that.
I know, I was using
No.
a silly example
You
to
can-
illustrate the
Assistant principal
question.
gives you a detention for throwing a pencil. The parent can appeal to the principal to say, hey, principal, I think the assistant principal has a beef with my child and was just being mean and doesn't deserve a detention because it slipped out of his hand. He was just playing around. You could do that. In this case, though, you provided a consequence, and then it starts the whole process, right? So right off the bat, you say to Mr. Hughes, the principal, Billy did this to me. Okay. You do the quick investigation, right? The first day investigation, right, during the day, and you go, yeah, it seems like a preponderance evidence that Billy did that. I'm suspending you for 5 days. And by the way, Mr. Hughes, do you want to start a Title IX investigation? Yeah, Title IX investigation. That's going to go on for a while. So you're not going to appeal the discipline. I guess you could appeal the discipline to the principal and say, 5 days seems harsh. No, I mean, chances are the principal's going to say, no, it's not. This is a Title IX investigation. It's done, right? So no sense in appealing. You got 5 days and the process is going to start. So
Maybe we could just clarify the language to say, like, the decision of the appeal is final and any punitive.
I'll look at that.
Punishments that have already been served. I mean, there's no way to rewind those unless there was I don't think we fine people.
Yeah, I guess I was just taking it from the perspective, if we gave something that was, overly punitive and a punishment, that there's no opportunity for them to appeal. Because I do think there should be.
I mean, you could imagine a situation where an incident happens in a pool and the student is told, you can never use the pool again because of your behavior. And then if they won the appeal, they should be allowed to use the pool again.
Correct.
So that decision, so maybe it's just clarifying that the decision of the appeal is final. There's no higher.
Yeah, because that's all under the appeal section, so, yeah. Greg, do you have anything else for 2266? Okay. Okay. No, no worries.
I think I'm good, sorry,
That's okay.
on that one.
Okay. Okay, so then we will move on. Next up is 2412. And then some context on this one. This policy has been revised to reflect the latest changes to the Pupil Accounting Manual. So similar to one that we discussed earlier, has that same change. And then let me see. Yeah, all the recommendations here are based on the current policy, et cetera, et cetera. All right, so 2412, Homebound Instruction Program revised. Does anyone want to start?
My bet was this would be an easy one today. There'd be like really nothing there, but maybe Greg got something.
I just have a clarification on third paragraph, 2412. Talks about a physician and a psychiatrist. I'm assuming that's a non-district physician, psychiatrist, okay. That's it on that one.
Okay, Ms. Custodio, anything? Mrs. Shaw?
No.
Wow, okay. Did Jeff say he was okay on this one before he walked out?
No idea.
Oh, he didn't say.
I'm assuming he walked out because he didn't have one.
Yeah,
All right.
all right, we can revisit if we need to, if he's got something for this one. All right, so 2412 is good to go. All right, 4162, controlled substance and alcohol policy for commercial motor vehicle drivers and other employees who perform safety-sensitive functions. This is a revision to the existing policy. This policy has been revised to reflect the statutory and regulatory changes to the return to duty process as required by the Federal Motor Carrier Safety Administration, including evaluation by a qualified substance abuse professional, education and/or treatment, and follow-up evaluation. This revision should be adopted to maintain compliance with current requirements. And then, Chuck, you didn't have any additional comments from you and your team? Okay, so 4162.
So bottom line, just turn it all the way to the back, really under return to duty. It just talks about what employee would have to do if indeed they, were found to be under the influence. And so they'd have to do all these things, and then no employee can come back without the express written approval or express approval of the superintendent. So You know, there are incidences where, if the board's not aware, we do random testing for anybody that drives a district vehicle. That's under the, you know, our insurance carrier, you know, we just do that. And there are times that people, you know, might have something, and we'll do what we have to do, and we hope that we can help them and get them back working, right? You're not always just going to dismiss them. You're going to try to work with them. So that's why the superintendent can't approve them to come back if they've gone through the process. So,
Does anyone have any comments on this one? 4162.
I'm good.
No? Okay. Assuming Kristen probably doesn't either, so. Moving on, let's look at 5120, copy of assignment within district. This policy has been revised in response to the U.S. Department of Education's specific focus on Title 11 and race in response to the United States Supreme Court's decision in Students for Fair Admissions versus Harvard, which prohibits preferential treatment based on race in college admissions. The decision apparently extends to any program or hiring practice which provides preferential treatment to any protected class. This revision should be considered for adoption. And let's see.
and that's pretty straightforward. It's
don't-
just
don't-
crossing off D.
Yeah, just reflecting revisions to the U.S. Department of Education. Comments, questions, anything on 5120?
Nothing from me.
Nothing here.
Mr. Scott? Okay. All right, moving on. 5460. We buzzed through a couple, Kristen.
Oh, wow.
Do you want me to, you want to just go on at 5460 is where we are? You want me to read?
I can read that right here.
Okay.
All right, so this policy has been revised at the request of clients to provide an option regarding universal FAFSA provisions that are required of districts participating in the MyLeap 2024-2025 Universal FAFSA Challenge. This provision is not currently required by law, but is necessary to secure funding offered as part of the challenge. This revision was issued as a special update in August 2025 and should be adopted by a district participating in the Universal FAFSA Challenge, which we are.
Yes.
So just to remind the board, you did adopt the FAFSA language in this policy. However, the state was looking for more information. So this was rewritten to meet the expectations of the state grant auditor. And so that's why it exists as it does now. That's a little different than the one you passed earlier. I think it was just a paragraph worth. So. And this grant is worth over $300,000 over a 10-year period, just so you know.
So on page 2, under C3, says the student agrees to opt out of completing the FAFSA. That's an example, or all four of those are applicable to exempt the student. But if they're not if they're a minor, how, I guess, does that apply? Or is it only if someone's of 18 to be able to opt out? Because how can a student agree to opt out?
Well, a student just might not want to do it. And so, I mean, the fact is that the student has to get the parents to cooperate, because in order to do FAFSA, you need your parents' financial information. And the parent and the student goes to the counselor and says, I can't get this information from my parent. They don't want anything to do with it. They're not going to give me that information. So the student just says, signs a thing saying, I'm not doing it because I'm opting out of it. As long as you have a document, you're good. You wouldn't think that would happen, but that does happen.
So would there's no parental involvement then in this situation?
Well, if you look at the options, right, first thing the counselors are trying to do is get a good faith effort by the student's parent, to sign the waiver, and they may not get a response from the parent. So then they're going to the student, okay, are you an independent, emancipated student? That way your parent's not, responding? No, I live with my parents, they're just not responding. The student says, they're not gonna give you the information, so that's step 3. And then step 4 is, there are some other things that a student can do, so.
When you complete the application process, you have a student and a parent, and they have to be submitted together.
Yes.
You can't have one without the other. So students can't do their part without parent, parent can't do their part without student. So unless you get, both parties to do it, you can't submit your FAFSA. So that's just how the process works with the federal government.
The voice of experience, thank you.
The voice of experience, yes.
All right, and then under K, same page, credit may be earned by A through K. There was an option for Neola that talked about a STEM endorsement. Is that something that we don't want?
No, I talked with the counselors, we have no need to put they have no desire to add one more step in putting a STEM endorsement on a diploma, so.
But does that help the student to have the STEM endorsement?
Not necessarily, as long as they're getting into college and they've got their diploma, they're good. Hasn't hurt any of our kids yet.
I will say from experience, I think our high school science department is extremely strong the way it is, so.
I would say too, for that purpose, our students can get the science honor cord. We still have a science honor cord, right? It's difficult to get, and if they get it, they're really showing a aptitude for science, so.
Yeah, I guess just looking for any kind of additional academic recognition. If it's something we could offer, I think we should consider it.
We don't feel it's necessary, but I understand.
I see where you're coming from, Greg. I just don't see that being a deciding factor for, like, let's say universities. I think it's more what rigor did the students take as far as honors and AP classes, more so than an additional endorsement.
But again, if it's what gets them over the mountain to get in, I think we would want to give them that opportunity. Again, that's just my opinion. I think that's it.
Okay, Mr. Scott, do you have anything on 5460?
Nope.
Ms. Custodio?
No.
Mrs. Shaw? Nope. Okay, thank you. All right, we are skipping 551701 per the discussion earlier. So moving on to 7540.02. Let me get to that page. Oops. One too many paper clips. Oh, do you need one?
No, I'm saying, are we going to keep going, or?
Oh,
I think
Well,
it's
You gonna
8:40.
go till 9?
if we can,
Last
yeah. We've got a handful left, but let's see what we can do. Let's see. So this is 7540.02, digital content and accessibility. This is a revision to the policy. Revisions to this policy reflect the U.S. Department of Justice final rule provisions under Title II of the Americans with Disability Act, requiring state and local government entities, including public schools, to make web content and mobile applications accessible to individuals with disabilities. And the recommendations that you saw in the packet were all based on the professional opinion of District's Director of Technology. Mr. Scott, do you have anything for 7540? Nothing? Okay. Ms. Custodio?
No.
Okay.
I have not.
Okay. Should we give Mr. Keller a moment?
Awkward silence.
Want me to check his computer? Usually he's got papers with like. in the
Yeah,
protectors with-
yeah, this was
Laminated?
probably too much to print it all and write out all the notes.
It was a lot.
It is a lot.
Is it, since we're waiting, do we have any indication of how much longer? Like, are we wasting our time by continuing to go through Neola policies if do we see a future? Do we think they're gonna be around a year from now? Have
Neola?
have we got any indication from MASB or Neola about what the plans are?
I went to the superintendent's conference in Traverse City and went to one of their sessions, and they have no plans on,
Neola?
yeah, they have no plans on,
So MASB's pulling support, but Neola's continuing without them.
yep.
Greg, we were filling the air, just to give you a chance to chime in on this policy 7540.02.
Try to check your computer. but you couldn't call it.
No, it's on.
Oh, I couldn't see the screen from here.
It's got a screen. What are we on, 7540?
Yep, 7540.02, digital content and accessibility.
Oh, yeah, already went through 5517.
We're skipping
No,
that
we
one.
skipped 5517 because there's the verbiage that Mr. Scott is going to send that is similar to 2266. So we decided we're going to pull both of those from the November vote, the November meeting. So we decided not to discuss it here tonight.
Okay, so I will skip my questions on that one then.
Yeah.
540.
Did you see your fence going up?
No,
Well, you didn't look hard enough today.
I wasn't over there today.
Okay.
That's awesome.
Fence is going up.
That's awesome.
While
Thank
we-
you.
While we're filling air,
Okay.
wait for Greg to jump in.
That's awesome. Thank you.
Yep.
All right, so in A,
Okay, right at the
75
top.
very top, yep. Says that the board, that will be hosted on the board on its servers or district affiliated servers. I think Neola removed that, but we did not.
That will be hosted by the board on its servers or district affiliated servers?
Yep,
Yeah.
so in Neola's template, that's removed. So I don't know if we missed that or if there was a conscious decision not to.
So Scott Usher reviewed this, and Scott Usher made the suggestions as you see them. So he made the conscious decision to say this is what his recommendation is.
I think the other ones that I had on here were more or less just formatting based on how the Neola policy had stuff moved around versus where we have it. Again, maybe it's not extremely critical because it's
Yeah,
all
if-
still
if the
there. but
content is the
It just
same.
probably makes it harder when there's updates that come from Neola because we're different.
Oh,
So it doesn't change meaning, but.
Can you send those
Yeah,
to Renee and
it's an ugly looking sheet, but I can share it with you.
we can look at it?
And then I think I was only questioning one strike through on page 2. The district website and web pages, app services must be hosted on board-owned or district-affiliated services. Do we know why we would remove that?
I'm sorry, which did you read? We're on page 2.
Yeah,
Well,
it's page 2, yep, right in the middle.
I would
Talks
say
about digital content published on the district's website.
we
Is
use
this,
Catapult, and Catapult is not owned by us.
okay, so it's like
a-
an
it's a
Amazon
contract,
service? Okay.
yeah.
one other one. This was in ours, so under third-party content, second sentence, it says programs or activities, and then in Neola's template, it says, or web services and apps that pertain to its programs, benefits, that's removed in their template, but not in ours. So I didn't know if there was
In what sentence?
second sentence.
So in the green?
Yeah, right after the green where it says activities, it says, or web services and apps that pertain to its programs, comma, benefits. On the Neola template, that's removed. So again, maybe we didn't want to do that, but just to be consistent with the Neola version, just pointing that out.
Again, I think Scott Usher make this recommendation, not to.
Oh, shoot. Yeah. Okay, I think I'm good on that one.
Okay, thank you. All right, moving on to 7541, which is electronic
That's
data.
rescind.
Yep, that's a rescind.
Oh, that's a rescind.
Yep,
Do you have any questions about rescinding that?
nope.
Let me just see what it says here to refresh us all.
It's here.
Provisions of this policy have been included in Policy 8300, Continuity of Organizational Operations. There is no need for duplicity in the policy collection. So this is just eliminating a duplicate.
8,300 is the next one.
Got it.
So,
Okay, so then let's forego any discussion on that until we talk about 8300 then. Which is, as referenced, Continuity of Organizational Operations Plan. This is a revision. This policy has been revised to include additional language and options regarding cybersecurity safeguards. These revisions should be considered for adoption. Chuck's comments, would you want to say anything, Chuck? Or I'll just read what you've got.
Took a look at this as well.
Okay. Revisions in this policy are considered consistent with industry standards. We do not recommend choosing the scope of continuity plan, which is referenced, I think, as one of the Neola options. All of the recommendations provided should be approved, yes. So,
8300 or 8305?
8,300.
Well, he looked at it as well, just to take a look at it. Because it talks about computer network systems and support.
Mrs. Shaw, do you have anything for this one?
nothing, thank you.
Ms. Custodio, do you have anything?
No, thank you.
Mr. Scott?
I'm good.
Okay. Trying to fill some air for you.
Yep,
Greg.
no,
Do you have
I'm good.
anything? Okay, you're good on this one?
Yep.
Okay. So 8,300, and then that would include then the rescission of 7541. Okay. Moving on to 8305. 2 seconds. All right, policy 8305, information security. This is a revision. This policy has been revised to include additional language and options regarding cybersecurity safeguards. And these are our insurance carriers' recommendations. This comes from Chuck and his team. We recommend adopting language such as the board would not agree to pay ransomware demands, for example. We also believe that all contractors should be included in this policy. So 8305. This
Again,
is
the key, this is, recommended by SETSAG as our insurance carrier, who we would be counting on to help us get data back and, what it costs to restore it and all that other, happened years ago, gosh, probably 20 years ago. What did it say about 20 years ago? We lost everything. Yeah, it was not pretty. Yeah.
Can't imagine.
Laura, you're so quiet back there.
I'm good.
Duly noted.
Greg, you're good on this one?
Yeah, I'm good.
Okay, Jeff?
I'm good.
Didn't know. You're good?
Nothing.
Okay.
Thank you.
Okay, good. Well, I'm glad we all support SETSAG. Let's see,
Last one.
last one, school safety information, policy 8400.
So this is not a Neola policy. Actually, I brought it up to Pat, our Neola person, and I say, Pat, we went to record information on the Michigan State Police website where you're supposed to, in the years past, we had to list crimes, potential crimes based on actions of individuals in the district. And when we go to the Michigan State Police report site, they say this site is no longer to be used, not necessarily, you don't use it. So there's no way to do it anymore. So the only recommendation we had was, might as well make sure the policy's correct and delete that section. That's the only thing that's the only reason why we brought it forward, because we don't want to delete something without your knowledge.
Has the state law been rescinded then?
I'm assuming since,
I think I heard it had, but I
Yeah.
don't.
I'm assuming it had, or the state police would still have to have that accessible. So. No other changes.
Does that mean it's optional, or does it mean you
You
can't?
can't.
There's no physical
Yeah,
mechanism
there's no
to-
mechanism to do so. Yep. I'm not sure what they were doing with it anyway, to be honest with you, if anything.
All right. Anything else on 8400? All clear? Okay. Wow. I commend you guys. That was a lot that we covered, but I'm.
You got 8 minutes.
We do have 8 minutes. Do you want, anybody want to do like a little soft shoe, a little dance up here, a little tap routine?
I know you have something prepared.
Laura's. All right, so we're good. We'll cover 2266, 551701, once we get some further information from Mr. Scott and then subsequently from Troon. And then we can revisit those as a team at our next policy meeting. All of these policies that we've reviewed, will be up for vote. They'll be on the agenda at the next meeting in 2 weeks. Same place, same time.
And I'll take my notes. I'll take my notes and get you guys some information based on what you've asked me to look into.
And then Greg, you just had the one follow-up from treasurer?
Yep.
Treasurer policy. All right, so I think we're good. We are adjourning, 7 minutes ahead of schedule. Thank you.